Good morning. Are you Derek Ardwan? And Mr. Ardwan was previously in court in cause number 25 DCCR 0350, entered a plea of guilty to the second-degree felony offense of sexual assault. The agreement was for a cap of...
Okay, right out of the gate, we've got a plea deal capped at 6 years. But here's the kicker. Just because there's a cap doesn't mean the judge has to follow it. That's where courtroom drama really lives. Will the judge honor the deal or chart her own path?
6 years in the institutional division of the Texas Department of Corrections. I have received the pre-sentence report. Has everyone had an opportunity to review that?
We have, Judge.
Any additions or corrections?
None from defense, other than something I'll clear up on argument.
Okay. Go ahead.
Well, Judge, when you review the PSI, it's several times Mr. Ardwan does take responsibility for what happened, for his actions. I know there was some talk from the PSI writer that seems like he was minimizing or still deflecting some of his responsibility in what happened. I did speak with Mr. Ardwan about that. He said that toward the end of their interview, he understood more what the PSI was saying because there was two people from probation there at the time.
Yes, sir.
And so as the second person started to intervene, he understood.
Okay, right out of the gate, we've got a plea deal capped at 6 years. But here's the kicker. Just because there's a cap doesn't mean the judge has to follow it. That's where courtroom drama really lives. Will the judge honor the deal or chart her own path?
And so he totally takes responsibility for what happens. He understands the situation. He shouldn't have been in, him or the complainant, during that situation. He was going through a situation with his girlfriend. It wasn't his wife. It's not his actual stepdaughter. His girlfriend, and started getting more attention from the stepdaughter than he should have, and he went along with it. Shouldn't have, but he did. It wasn't a situation where someone was underage or anything like that. She was definitely of consenting age. Being in a relationship with him, they had started hanging out a lot more, almost in a dating scenario, if you will. And then it escalated to the point where they were together that evening. Nothing of force, anything was happening. To my client understanding at the time, he thought everything was consensual that was going on. It wasn't until later, until this investigation, that he realized her stance or argument of her being intoxicated to the point where she couldn't give consent, legal consent or anything during the activity. I would like to point out with him, when you look at his criminal history, he has not had any type of criminal history since 2001, since 2001. So since he was in trouble that one time, or that last time there, he has done everything he can to try to keep his life on track and not revert back to any of the old activities he had when he was younger. My understanding is, he does have a lot of family support. I've been in touch with several members of his family that have reached out to me. My understanding is that the mother of the complainant is still very supportive of him. And to the point where, even though he moved out and was away from her and everything like that, she still wanted to pursue their relationship and work on their issues. He is asking that the court consider community supervision.
Notice what's happening here. Defense is painting the relationship like a messy dating situation instead of a crime. But legally, intoxication changes everything. Even if both parties are adults, consent disappears the moment one person is too impaired to give it. That's not just a detail, it's the entire case.
In this situation, I think it definitely could be appropriate here in a situation where he's a registered sex offender at this point, so he will be able to get any of the attention or that he needs through any sex offender classes or through their registration. As well as, I think that there's several vehicles available through probation that could help with any other additional issues that he does have. So at this point, Judge, we are asking the court to consider deferred adjudication in the situation with Mr. Ardwan.
Thank you. Ms. Malvino?
Judge, although the PSI reflects that they were unable to contact the complainant, the notes in the case reflect that our office has, and she seemed cooperative and wanting to go forward with the prosecution based upon that, based upon the nature of the offense, the circumstances that even Mr. Lewis himself has described with respect to, she may be considered a legal adult, but the difference in their age is quite substantial. Obviously, he took advantage of the fact that she was making bad choices with respect to drug and alcohol use and got herself in this position. So on her behalf, Judge, the state would argue for the 6 years under the cap, but defer to the court's discretion, of course.
Thank you.
And if I just may confirm, in case the question arises, he has already completed the sex offender registration paperwork.
Oh, yes.
Yeah,
Yes,
I think we did that at the plea. Mhm.
Just check.
Thank you. So I guess my thought is on this, I don't disagree with Ms. Malfino that prison time isn't necessarily warranted. It sounds like you got yourself in a predicament that you're way old enough and grown up to know better. She wasn't a minor. There was a lot of things that looked like they were consensual up until a certain point where y'all probably, it sounds like we're both so intoxicated, you clearly didn't know what was going on. 6 years, you're out in a few years. There's no treatment. There's none of that I think would be helpful. And so I think to me, the better and maybe.
Here's a question for you. Should community supervision ever be an option in cases like this? On one hand, probation forces accountability and treatment. On the other, prison time sends a clear message about consequences. Drop your thoughts below. I'm curious where you land on this.
The more difficult thing for you is a probation, because this type of probation is not going to be easy. So what I'm going to do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 10 years. There's two things that are, well, let me finish and then I'll go through some other stuff. I'm going to order a $1,000 fine. I'm going to order that you follow all of the rules and conditions of probation, and that includes entering and successfully completing a licensed sex offender program. To successfully complete the program, you also have to admit what you did. So it's very important that you get in that program, you take responsibility for your part in what happened and how you got to this position so that you're never in this position again. You're obviously already signed the paperwork and understand that you will be required to register as a sex offender. If you don't register timely, then that's a violation of your probation plus another felony offense. And so you've got to take care of everything you're supposed to while you're on this probation. So the good thing about that is it's a deferred probation and there's not a conviction. The good thing for me and potentially Ms. Malfino later is that by doing this deferred probation, that cap of 6 years is off the table. Okay, that's over today. I didn't give you prison time, so that's gone. If you violate this probation, I then have the entire punishment range, which is 2 to 20 years in prison if you violate. So there's no coming back and saying, I want the 6 years or I violated and don't, I've got the whole range. I'll look back at this and I'm sure I'll be reminded at what their argument was, and it's not likely to be 6 or less. You understand? So I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Now, obviously, a part of this probation is that you have absolutely no contact and no communication with.
And here it is, the curveball. Instead of prison, the judge flips the script with a 10-year deferred probation. That's actually tougher in some ways. Constant check-ins, mandatory treatment, zero room for slip-ups. One mistake, and the 6-year cap is gone, replaced with up to 20 years. High-stakes chess, right here.
With the victim. And so if there's some relationship that you're still having with her mother, it cannot be at a place where she is. You cannot go to wherever she's working. If you go into a restaurant and then she comes in after you, you're the one who has to leave. It's up to you to remain away and not have any contact or communication. You understand? Yes, sir. All right. Good luck. Thank you, Mr. Lewis. Good morning. Good morning, sir. You're Jesus Ibarra? And this is 23 DCCR 2253. Mr. Ibarra's case is set for trial to begin with jury selection next Monday. And what is the announcement?
We'll be ready, Your Honor.
Right.
Stay true.
All right, I want to go make sure, let's see, what was the previous, has there been any other negotiations or
It
offers?
was a cap of 8, Judge. I did let Mr. Jeffries know in docket yesterday before he met with his client that I was open to having further discussions. It's my understanding that it is okay.
All right. So I want to make sure you understand, Mr. Ibarra, it's likely your case will be the number one case for next week, and there will not be any plea agreements accepted after today. Do you understand?
Yes, Your Honor.
All right, and so you want to still go forward with your trial next week?
Yes, Your Honor.
All right, we'll see y'all next week. I will number the cases and let you know after docket, but I anticipate this will be the number one case.
Yes. I may ask if I could get maybe a protective order. I'm on a trial docket in Polk County as well, not number one, but I'm there.
We'll get that done as soon as it's numbered after docket. We'll get you protection so that you're here, since your client is it anything older or a kid case or anything like that up there? Okay, all right, then we'll make sure and take care of that so that you're good for next week.
Thank you, Your Honor.
Thank you. So just make a note to get that. Ms. Holmes, you have Christina George.
Shannon, we can hold on that one.
Sure.
I'm ready on Mr. Frazier.
Okay. Jacoby Frazier.
Yes, ma'am.
Got it.
I'm ready.
Good morning. Thanks, ma'am.
Yeah, that's.
All right. Are you Jacoby Frazier?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Frazier, in cause number 25 DCCR 0732, you're charged with the third-degree felony offense of obstruction or retaliation from May 18th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Freely.
Okay. Did anybody force you to plead guilty?
Uh-uh.
All right. I have here on the computer some documents that have your signature on them that it looks like you went over with Ms. Holmes. Did she explain those documents to you before you signed them?
Yes, ma'am.
And do you understand those documents?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 4-year deferred probation.
With 5.
There's 4-year probation and then a $500 fine. Does that sound right?
Yes, ma'am.
And you understand as long as I follow that agreement, you can't change your mind later.
Yes, ma'am.
Okay. And are you a U.S. citizen?
Yeah.
Okay. State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Frazier is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case so the probation department can do a pre-sentence report. That'll give us more information about you and your case, and then we'll come back later for sentencing. Ms. Malfino, what is the state's?
I have no
Position.
objection, Judge. He has one misdemeanor evading. I think the PSI will probably come back and show us all maybe some specialized caseload.
Sure. So, Mr. Frazier, if I reduce your bond, where would you go live?
6655 Dow Street in Groves, Texas.
Who do you live with there?
My grandma and uncle.
Okay. So here,
Actually, grandma owns a house, but she stays there most of the time.
okay. So do you have transportation to go to probation
Yeah, I
and
have
things
this
like
lady
that?
named Miss Charlie. She works at Motiva. She had brought me to court, but tell me to come back, but I didn't come back. But she'll bring me.
Okay,
And I cut grass. I have my own lawnmower.
good.
Weed eater, I couldn't use it, so I gave it away for free.
Okay. I don't want there to be any issues with showing up for the pre-sentence for that interview. So I'm probably going to leave everything the way it is so that we have a good plan in place with that pre-sentence report. And then that way, hopefully there won't be any issues and we'll have all the rules in place, okay? So I'm going to leave everything the way it is now. We'll see you back here in just a few weeks. And then at that point, you'll get out and be on probation, okay? All right, go back with the bailiff. Mr. Lewis, you have Robert Eaglin.
Robert Eaglin? Thank you. In my mind.
Quick legal nugget. No contact orders aren't just about staying away. They flip the responsibility completely onto the defendant. Even if the victim walks in, it's on him to leave. One wrong encounter, even accidental, could unravel the whole deal.
Good morning. Are you Robert Eaglin?
Yes, ma'am.
And this is 24 DCCR 2382. Mr. Eaglin's charged with aggravated assault with on a family with a weapon, and case set for trial to begin with jury selection next Monday. And what is the announcement?
Judge, the state needs to announce not ready. I have spoken twice in the last week or so with the complainant. She had a stroke. She actually called me from the hospital.
Okay.
Tell me that she had just had a stroke. She has to do some therapy to be able to be in a position where she could clearly testify. She is cooperative. She understands the ramifications. She's checked in again yesterday, nervous about what my announcement was going to be. The court will see that case. The offense date looks a little bit older. It was originally in CBC. Mr. Laird had it. They could not locate her. At some point, it was then dismissed. When they did locate her, when she saw something on the news or on social media, it was refiled. It came here, so it's actually just been through maybe a setting or two, and this is a first trial setting. So
Okay.
I would respectfully ask for a continuance to allow her to rehab and then be able to.
Okay. I will grant that, and we'll reset it to the next available trial docket. If there's any issues or motions that need to be filed before then, just let me know.
Okay.
Okay?
No problem.
All right.